legislative, this is your laws and codes, right? Normally you get session laws and then, statutes, and then they get sort of put together and they become the codes, right? But maybe by the legislature. What does copyright protect? So, original works of authorship, stuff involves some creativity, not basic facts, basic system stuff, something that should be on patents. So the basic things, it's looking for stuff that's creative, not mechanical, is probably the way to think of it. And then there's, fair use as well. AI doesn't always get it. AI is just auto-completing stuff. If your data's bad, it'll autocomplete bad stuff. If your data's old, it's going to autocomplete off old data.
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I will be the moderator for today. But for now, let me introduce our speaker, Tim Stanley. Tim Stanley is the CEO and founder of Justia, one of the most visited legal portals in the world. Before founding Justia, Tim founded and was CEO of FindLaw. He is the general counsel on the board of trustees for public.resource.org and was previously on the board of NOLO and American Legal Net. Tim has a bachelor's of science and a master's of science from Stanford University and a Juris Doctor from the University of Michigan Law School. The webinar presentation that you're about to watch will be approximately 1 hour, and then Tim will be taking audience questions once the presentation is complete. If you have any questions that come up that you'd like to ask Tim during the presentation, please feel free to place them in that Q&A button at the control panel at the bottom of your screen. Now, without further ado, here is Tim to discuss free law, resources, technology, and legal issues, past, present, and future.
All right. So I'm going to cover, free law, a little bit about the free law movement, and some of the legal issues, and maybe a little bit of some of the technical issues that we've been facing in terms of getting information out for free. But it'll be a slightly different discussion than what you might have seen if you watched the ones from Craig and Sarah Legal Information Institute. This is I'm not trying to do hands-on stuff and really get into all the details of using free law and public citations and things like that. I'm trying to get a little more in the history stuff and a little bit more in the background of what was going on for people like myself and other folks just trying to get a law online for free. Here are two of the main sort of culprits in the free online movement. Really, one of the core founders, Thomas Bruce, and then Carl Malamud, who's more than just laws, put up lots of stuff. Edgar, patents, all types of things. He's helped get online for free. But these are the types of people that I'm going to be discussing and sort of showing pictures of while we talk, and then I'll get into some legal issues as well. In the discussion, first I'll give the overview, a little bit what I'm doing right now. Then I'm going to dig into the legal issues a bit. A lot of it's copyright, but some privacy issues, different things like that, and sort of go through a few of the more important cases that have occurred that have led to, I think, decisions that have been overall positive for getting information, especially government information online for free. I want to talk a little bit about free law and AI, and to a certain extent, you could think of this as government information AI. I think, for training AI models and different things like that, there's a lot of government information that can be used for that, and that can be really, really good. Also, there's still the same similar issues of copyright and privacy that they can show up. And then very, very quickly, I'm going to run through some resources, which, point out to Justia, LII, public resource and fast case, folks like that. So with that said, let me sort of just start the discussion. All right. Long time ago, this is back like 60s, right up until Lexis really started putting some stuff online when they were part of Mead back in Ohio. People use books. Even when I was in law school, a little over 30 years ago, I'd go read a book and I would do shepherdization using a book. And even though I had free Westlaw access or free Lexis access, they still really pushed us to use books. I don't think a lot of people use books anymore. I'm not saying they aren't used at all, but they're not used as much. And I don't think, obviously for folks like Thomson West, it's not really the business model. They still have a publishing arm, but, their revenue's really moved online as well as to get into the infrastructure law firm. So everything has sort of changed. But there was a particular time where books were really the focus. That really, the bigger change, initially occurred with online systems like Lexis, and then later with West, first with their head notes, and then adding the full cases in. But most of it really occurred because of the internet. The internet's really what's driven almost all of the ability for people to access information these days. Um, so I want to quickly just, not a ton of detail, but I quickly want to run through, the government, law schools, and then a little bit about the nonprofits and LAI and free law folks, and sort of what they're doing, what they can do. It'd be pretty basic, but let me just sort of run through this part. First, if you took a civics class, right? You got the legislative, executive, and judicial. Legislative, this is your laws and codes, right? Normally you get session laws and they, statutes, and then they get sort of put together and they become the codes, right? But maybe by the legislature. Executive folks, president, governor, they run the state, they run the federal government, they're running regulations. The regulations are related to the codes. Right now, the agencies that run it, should be getting deference. We'll see if the Chevron decision gets overruled or not in a few months. That might change a lot in terms of how regulations are looked at. But right now, certainly you see the regulations, and you might also look at the interpretations from the agencies as to what their calls on the regulations. In July, you might be looking at what the courts say, or different courts say about different things. And of course, the courts, judicial opinions, Supreme Court stuff, different things like that. And all the courts have opinions. All of this stuff is really, from a lawyer standpoint, this is the raw stuff that you use to really research and do your job, right? When you're talking to non-lawyers and they're talking about their day-to-day stuff, what they're really focused on for the most part, the codes, the laws and the codes and the regulations. So the case, they might read the cases because it's, on cable news or something, they go back and they read the decisions. But to a lot, if you're doing a building contractor or something, you're not necessarily following the latest decisions, but you do want to know, what's the code that I need to do to actually put in this refrigeration unit, things like that. The states and the government, from starting at zero, they've got a lot of stuff on. So, there's a lot there. So, if here's the U.S. code of the House, say the Cornell has a better, cleaner, easier to use version of it than the federal government does, but they have their own copies of. The ECFR.gov, they keep this up to date, daily. So this is very, quite good. And, it's gotten better and better over time. You can see different change files. I mean, it's really nice on that part. And of course, you got a lot of the federal courts, the state courts have documents up, the decisions, and a lot of times the briefs, the oral arguments. You can also see like Ninth Circuit will put those on YouTube, for example. Court of Appeals in New York puts them on YouTube as well. And then you have Pacer where you see all the filings, right? This is all you can file the dockets, you can see all the attachments. And the one thing with Pacer is if you get more than just a little bit, if you just get a case, most individuals can probably use it for free. But if you're using ongoing, or if you're someone that sort of aggregates data, it does cost money. Although there are some folks like, Free Law, Mike Listener and Brian Carver and the guys who've taken over Recap that are using sort of group sourcing to free up some of these documents. But, a lot of this stuff's online for free and it's pretty good. The one thing that we don't really see a lot is really good standardization of the data to actually be able to move it to different platforms. So I might see one thing in Texas, I might see a different thing in Michigan. There's not a lot of consistency. And that requires them work to pull the data down. Sometimes you might be just scraping the data and have to put it in. Other times there might be some XML files. On the case side of things, some states, they'll put up the final official version with their own public domain citations. Other folks, they put up slip opinions, and then the slip opinions aren't the final official ones. The actual official ones will show up in a West book, right? The Thompson West book. So there's different issues like that pop up. There's probably a little bit more on the decision side of things. Regulations and things, states and folks might not be like the CFR. They might have different publication schedules. They might publish monthly or quarterly the new regulations, even if the regulations took place earlier. So a lot of work, and I'm not going to say the government have done a bad job. I think they've done pretty good for what that they have and sort of the resources they have. But it's federal government in 50 states. So it's not really easy to sort of grab everything and sort of put it together. It's lots of little pieces. So if you're trying to make, like, if you're someone like VLEX, right, or Fastcase, and you're really trying to come out there and compete with Lexus or compete with Westlaw, you got a lot of work to do. That's just manual work before you actually do all your really cool AI stuff with all your summary stuff. So there's a lot of stuff that goes on there, and it's constant work, updates. I mean, a lot of people, hey, I scraped the site, I put it all up. And now I got to do the updates. And that often takes a lot of time. I know it does for us. We spend a lot of time on just bread and butter work, is the way to put it. The other group sort of is the law school. So the law schools also have done quite a bit of stuff. Chicago can obviously been a leader in lots of different online stuff. Harvard has this case law project with all the cases that they scanned in, which, by the way, will become available for everybody, in like 6-7 weeks from now. So sometime in March. So that'll be nice. But so law schools put up a lot of stuff, but you still sort of see things where they're sort of working with either private companies or, in this case, law reviews, where they're not making everything as open as free as they can, right? So here's a bunch of law reviews. They own the blue book, and they've made different threats when people tried to put things up, although it was a copy that they had not properly renewed their copyright on that was worked on the Indigo book, which I'll bring up in a little bit. But you still see certain things where there's where some of the law schools or sometimes student organizations are sort of pulling back and not making everything open and free. You see things like something that could be a large sort of academic type group project, similar to like what the physics folks had done. You see sort of taken over by private businesses. In this case, SSRN, which I was one of the initial programmers for it back in the 90s. But they had the Legal Scholarship Network, and that was part of a bunch of different social science networks they put together. It's now part of Reed Elsevier. So it's sort of with Lexis in terms of things, as is BE Press, the other one that sort of competed with them. They're both part of Reed Elsevier right now. But this gets a lot of the working papers, right? And it's also, with BE Press, where it controls the submissions of the law reviews and different things like that. Again, taken over by private organization, with the law school sort of stepping back and saying, hey, you take it over. And I get, law schools have lots of different issues going on in terms of, getting students to apply, sort of running things, raising money. There's lots of different things. It's hard to do projects, which are sort of be group projects and different things like that. The other thing, but by sort of making a combined one though, and also sort of hits the law schools themselves, is they got ratings here at SSRN, right? So who doesn't want to be the top rated law professor for downloads and things like that? So there's these ratings also play a large part of everyone to be on SSRN, and sometimes get some professors not to want to put their own papers up on their own law school website because they don't want to lose their SSRN ranking, which, some law schools have also used to decide tenure decisions and things like that. But sure, downloads should necessarily be the way to decide tenure, but I'll leave it for there. So there's lots of things that law schools could do together, which they haven't done everything. And so to me, the law school projects, there's a little bit here, there's a little bit there. And again, just lots of different projects going on, but there hasn't been anything that's sort of, there doesn't seem to be a lot of coordination. You don't have something like a Thompson, that's a coordinated effort across a bunch of different things. Same thing with Reed Elsevier, coordinated in terms of what they're doing. In law schools, and when you have a bunch of law schools sort of competing with each other, doing different projects, the resources aren't optimized. There's a bunch of things that go on there. One of the folks that can help coordinate it and has been helping coordinate is Callie, right? Main office in Chicago camp. They got folks at Emory and different places as well. And so these guys, certainly are sort of in the middle of it. And when I sort of think of things, I can sort of see how they can sort of coordinate stuff and put things together. So they work with all the different law schools and help them with, with educational materials, but they've also been involved with access to justice and other things to really help folks in clinics and stuff reach out to people, right? Always focus on the law schools, but also trying to help the law schools help people and train new lawyers in terms of how they can help people as attorneys when it comes forward. All right. So that's a little bit of the government. Pretty good job, but not standardized. Lots of different states. And the law schools, again, not standardized. Lots of different resources being used different ways. Often, one professor has an idea and, goes for a while and then it doesn't go. There's different things that happen with different projects. So there's issues, but a lot of it, there's just so many different groups there with different levels of funding and not a lot of standardization in terms of what's going on. Let me go into LII and the free law folks. So LII is Legal Information Institute. It's at Cornell Law School. And this is what it used to look like. In fact, it didn't even look like this. Back in the days that it initially came out, back when I first started using it, it was a Gopher site. It was just text-based, right? It was like the old, I don't know, CompuServe or something before they had like a graphical interface. It was just all text, right? and you would just type stuff in and go for stuff. You just go through different directories and you would get things back, almost like using DOS. I guess is probably the way to think of it. I don't know if people still know DOS, but it was sort of like that. So it was go for stuff, and then they were some of the first folks on the web. I mean, the legal sites are the first main one. And this is Tom Bruce and Peter Martin. They were the co-founders of it. Tom, probably one of the most famous guys out there in internet world, especially in terms of law, but just in general. And then Peter Martin was the dean at Cornell Law School and really helped push the stuff, and really himself sort of pushed things along too, right? Just sort of helped getting information out there free when different organizations would challenge them in terms of legality of putting stuff up. Not afraid to fight back a bit. It's probably a good way of putting it. Here's a video that's up on YouTube right now of Tom Bruce back in 1993, talking about what the internet is, right? And why you should care. And Tom has credibility, not just the main sort of legal website for everybody in terms of the free law movement, but also wrote the first web browser for Windows. All right, there's a lot of different things that go on. I mean, I know that back in my early days when I was doing fine law, I basically my initial thing I did is I just made links to LII, right? I used to also work on the Yahoo site back when it first came on campus, and all I did was go through different practice areas and add different links into the Cornell. I mean, that was 90% of what you could do because they had all the best legal links. So is LII itself, just as from a historical standpoint, the first ones that really got it going. They were bringing the Supreme Court decisions in. They do it, and they started adding stuff with the codes and different things like that. But really, sort of the main folks. It's still to this day really the main one in terms of like the free law folks. I mean, so all of us sort of look at them as the main folks, and that's who we work with and different things like that. LII itself in Cornell led to a lot of LIIs internationally. Now, I'm not going to focus too much on an international standpoint, but if you look in the world, there's the Cornell's the first, the main LII, then it became Australia, and those two guys have been sort of the ones that have helped others do it. And just a lot of them. There's an Australian one, and then we go, bam, 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 just a ton of these. Just a lot of LIIs. And well, not yet. Okay, and then the World LII stuff, which lists out all the LIIs. I just chose the ones that were named LII, right? There's a lot more that some of these guys, not with the plan, they changed their names. They didn't say Legal Information Institute like they should have at the end of it. But these were all the ones that, not all of them, these were a selected bunch of them that said LII. There are actually more than the ones I just showed. But all this was really driven, by Tom and Peter sort of starting at the US and sort of pushing this stuff up, getting things up on the web earlier, and having other people sort of copy their example. And then they would also help them with code, help them with setup, lots of different discussions. And again, every country has different issues for getting free law online, right? It's not all the same. Some have different privacy issues, right? Like the Canadian one, they're not going to allow Google index it for different privacy issues. Canada's a little bit more focused on privacy. So there's all these different things that sort of go on with it. But again, the core folks that started was the Cornell folks. So, you're the folks running today, Craig and Sarah. So they're running the LII. It doesn't mean, Tom and Peter are still around, but these guys are running it day to day. And here are people that lots of students work at LII right now at Cornell. They have a lot of people sort of working there and helping out, just a ton. And here they are having a party. So this is sort of the world of LII. So you can sort of see Craig in the back there, and the second picture too, sort of maybe giving people cake. So LII itself has continued to be the main one, and they just a lot of student participation. They write Supreme Court previews. They do all types of stuff. Build out the whole sort of we have a legal dictionary, but they got like a real one that's sort of more aimed towards attorneys. It's really fleshed out a lot. It's really really nice. Lots of different things that they go on, as well as their bread and butter programming stuff. They're doing AI projects. They're doing stuff with the regs, all different types of things they got. And then here's Tom and Peter today, or last year. So still kicking it, still around, and they're like giving the background advice and sort of driving the world. Just a few other sort of law school stuff. going on here. I'll just give a few more. Harvard did the case.law stuff. They did this with Ravel Law, which is now part of Reed Elsevier and Lexis, there. This is, they scan in all the books, the West books, and they put them online. You can get them through PDFs. They also have the text underneath. Again, you'll be able to get all this if you want this stuff in 6 weeks, something like 5 weeks, 6 weeks. They'll be out pretty soon for everybody. So it's very, very soon. If you want it in batch, you can. I'll just sort of leave it there. Go check it. Case.law. Rutgers has done a lot of stuff with the codes, different cases and things like that. So there's a lot of things that goes on with Rutgers. Just to give you an example, they probably, have done a better job on certain things and finding changes in codes and things like that. Sort of set that example for a lot of the other folks on the states. And again, very, very good site, and very John Jurgensen sort of runs it, and very, very good, technically very good in terms of usability. Duke has led the way to a certain extent on the open journals for law journals, making sure they get access out there. I mean, other folks have done as well. Rick Cloud did the first one with the Journal of Law and Technology over at Richmond many, many years ago, 30 years plus ago. But a lot of folks, and Duke's really been focused on that and trying to get open journal standards going. And then Jurist, which is run by Bernard Hibbets out at Pittsburgh, really initially started as a place where law professors would write articles, probably similar to Justia's verdict today, and then has now become sort of this worldwide organization of students writing about different legal issues in their countries, and they're everywhere. They're in Afghanistan, they're in Ukraine, they're all the places to the hotspots, but also here in the U.S. Right, we got legal issues here. It's not just international. So really has made this. It's really quite interesting. Just in the last 5, 6, maybe decade, 5 years or so, moved it and just sort of reached out to this international rule of law focus in terms of what they've done on it. So really quite good, and we work with them on that as well. Other ones is this Northwestern, Chicago, Kent, Cornell, really part of LII now in terms of OIA, which has all the oral arguments of the Supreme Court cases going back, initially put together by Jerry Goldman, who's still someone involved in it and doing some additional stuff that'll be coming out soon involving OIA. And Civil Rights Clearinghouse at Michigan, that we do some work on that. These are just ones that we work on. And we work on a ton of academic stuff, copyright site for Stanford. We do a bunch of different things with them too. Again, there's lots of different projects, but the one thing I would say you see here is that LII is sort of this overarching thing that's sort of pushing things forward. The other folks, we have little projects here, right? And that tends to be law schools in general. Just lots of little things going on. And so the ones here, good examples of free law stuff. I don't want by any means say that this is all of them. But how do we standardize stuff? How do we share code and things like that? And again, that always gets me back to the Cali guys who've always been the best in terms of getting people to sort of work together. So with that, that's the law school part stuff on the free law. These are the main free law folks. But again, you see some of the projects, but you also see the old school jurist. Some of those guys have been doing it forever. And then case law, that law with Harvard in terms of getting a big, large archive out. On the nonprofit side, so you have the Free Law Project with Court Listener, and this is Brian Carver and Mike Listener have run it. They started this a while ago, and then Mike's doing a lot of the programming stuff on it, and Brian's working with Google. But these guys have done a great job. So they've really got a lot of information up, and it's not just getting the cases and different things like that. They took over the Recap project, which allowed people to add a plugin. So if they grab documents from Pacer, they could share it with everybody. So you pay for it once, it comes through, it goes to the archive, and then they share it out with the whole world. They also take copies of everything, goes to the Internet Archive. We've had our stuff, go over to them as well in terms of different raw data on different items. And they've also done things like, things that you always see, but like the FOIA requests to sort of go through and look at, what are the investments that particular judges have, right? And then you see a Wall Street Journal article written about that. A lot of that information and some of that data comes in from Mike. So this, this site has really done a lot in terms of increasing just raw access to the materials, but also in pushing the discussion forward and trying to open up Pacer and trying to open up transparency, especially in the legal sphere. And, pretty aggressive in terms of their approach towards the courts, probably more aggressive than I am in certain ways. But they've, hey, listen, here's the proof, man. The site's a great site, and they use it. So really, really good. I use this site quite a bit, especially when I'm looking for dockets or documents for something. I love the free law site. Again, a court listener is the one that actually tracks everything in terms of it. And if you're downloading stuff on Pacer, you should have the recap plugin. And then if you download something, it'll be shared with everybody, right? Internet Archive, Brewster, always been sort of one of the backbones of things, right? With the free law guys, as well as publicresource.org, archiving everything, right? And doing some new, he's got some new stuff that he's putting together right now, also in the legal area, which I'll wait for him to announce it. I'm not going to bring it up yet, but it'll be quite awesome. The really, I think, from making information accessible, he's not just law, but just information in general. He's been sort of one of the main driving forces behind it everywhere, right? With all the libraries. So there's always been sort of the Internet Archive, and there's been a little bit with Google and Google Books. And there's a little bit of conflict there because Google Books sometimes locks people out if you're not academic institutions. He's basically trying to get stuff out to everybody. So I think he's done a really, really good job. To the extent there are any limitations here, it's only limitations by the being in the United States, right? The other, some of the places that have all the science articles and things like that are in Russia and things like that don't have copyright laws necessarily being enforced on it. But those things exist. But as far as doing things and just trying to get out here in the U.S., this has been sort of the main place that to get stuff out. Again, we've sent lots and lots of stuff over to Internet Archive throughout the years. And then publicresource.org. We remember the very beginning part with Tom and Carl, and this is the Carl, right? And so Carl, the first internet radio guy doing stuff back in the 90s, free Edgar stuff, patents, and now law, and not just U.S. He's not just case law, right? He's doing case law, codes, regs, international, doing stuff in India, doing stuff in Europe, lots of different things going on. It's a lot more. You won't even be able to touch you look at the website and you won't even be able to touch the sort of the tip of the iceberg on things. So just lots and lots of stuff going on with Carl. All right. This is an old picture of Fine Law. This is back in the old days when we did it. We were focused on free law stuff. This is me and, Vasu and, especially Ken, Dave Paz, and obviously Stacy and Martin were there. We gave Walkup, some of the other guys that helped us with free law stuff. When we started Fine Law, we weren't thinking of a company. We actually tried to get this done by Stanford. Back then, they didn't quite have interest in doing free stuff at that time. But we did long time ago. Fine Law is very different today. This is before their marketing solutions and everything else. This is when it was free law. That was the focus. How can we make more stuff free? And, again, Yahoo 1996. You in 2 columns. Nice. Now, of course, we do Justia. Justia has lots of free stuff, but, we got lots and lots of documents online for free. We also give data dumps of stuff, right? So you can get a lot of our data dumps on a daily basis and different things. So do a lot of sharing of information. And we're just like everybody else, we're doing AI stuff and, summarization and categorization of different things, as well as, doing some marketing stuff for lawyers on the directory and websites. Case now they're part of Thomson now. So we'll have to see what sort of happens here, but they've got the AI stuff going for the briefs and things like that, which, is a GPT-4 and sort of really segmenting out the data, the different data sets to get better autocompletes on it and using some of the prompt stuff they have. But they also have a lot of case law and codes online. So it's not just the AI stuff. In terms of getting free law stuff, there's a lot of stuff here. So them and Ramble had a lot of stuff that they got when they're at Stanford, and it's still there right now. So longer term, I don't know exactly what the plans are for case texts, but they've got, obviously they have their own products out there for law firms in terms of AI and the co-counsel product. But there's also stuff just on the free law side. There's quite a bit there. Fast Case, Fast Case is free to most people in bar associations. I mean, Ohio has a separate one with the one that's connected to Lexis and Reed Elsevier. But Fast Case, we have it through California if you belong to the California Lawyers Association. It's just sort of attached to the bar if you belong to any section. But they've certainly there's lots of stuff that they can get that you get if you're a lawyer for free through them. They've also been one of the main suppliers of free law stuff to publicresource.org and then to everybody else, right? That's been like the regs right now that Cornell and us have to deal with a fast case, right? Cases in the past. So they've done a lot of stuff on the free law side, even though they, technically are working with bar associations. But even beyond that, they're relatively expensive if you did have to pay for it. And they're part of VLEX now. And VLEX, with fast case and VLEX, be very, very strong in terms of what they're doing. And of course, Google Scholar, always good, right? They've got lots of different stuff there, lots of different cases. So it's free, right? Which is nice. So you can go there. And very good ways of looking how cases are interlinked together in terms of the text around it. So some of the folks have used things like the parentheticals, like the big focus of case text in terms of how a case is related. They look what's on the parenthetical of a citation. Google also they're so good at data, right? They also bring you all the different instances, how the text is worked around it, different things like that. So quite good on that part, and really been a big part of free law. And then Unicourt, Unicourt obviously has a lot of dockets and things online. They've done a lot of items there, but they've also helped a lot of the public resource projects. So helping get a lot of these codes and stuff that you see when, Carl's putting them up on publicresource.org and sharing them out with people. The real sort of work to actually get this sort of into the XML has been done by the folks at Unicourt. So they've been both providing docket information, lots of other stuff like that you can get by visiting your site. But beyond that part, they also have helped on the free law movement on sort of doing the raw work. They just, Upcode's also a great place to find codes, especially building codes, right? They basically focus on building codes, which tend to be the ones that you don't always see, right? Which I'll bring up in a little bit. And then once CLE has contracts, Law Insider, again, also a great place to find contracts. These are contracts from SEC documents. We also have it on Justia, but these are sort of the originators of it. And all this stuff really came from the SEC, right? These come from SEC filings. And the SEC filings are online. Again, it gets back to Carl. This is 1994. He was the first guy to put Edgar online. So he didn't have to go to Sunnyvale and sort of log into a building or something like that back in the old days. Really quite early. And of course, he got patents, got to get patents up during the Clinton administration, and is now doing cases, codes, everything else. So very, very early with Carl. And then a lot of good government sites. GovInfo is, quite good. You got different states, like here's Florida. They've got good versions of all their codes. So you see just a lot of different stuff. And there's a lot of people in certain parts of government that have really pushed to get public access going for it. I think this is an area where I don't know if Congress today's exactly working on it, but in the past, Congress, whether it's been Republicans or Democrats, have done a really good job in terms of getting things out. So it's been quite impressive what they've done as well. And then some states, Sunshine State, they've got a lot of stuff. Look at all the years that they have the codes back to. Other states aren't like Florida. Florida does quite a good job on it. Now, that brings me over to California. Just to give you an idea, some things, sometimes you'll see things, and there's different ways to find stuff. But like here's California's code. And that's okay. At least we save the titles in the internal pages now. But like what you want to see here is the building code. Well, the building code is private code. So they go through, if you want to get the building code, they go here to the division of the state architect. You'll send you in the Building Standards Commission, and they'll put a link off to a paid site, and you can buy it, right? Now you can pay monthly for $25 or annually, 3 years, right? You can buy the code. Or you can go to Upcode so you can just read it right now, right? And there's different, this is one of those things where it's a private code being used for government standards, some of which involves criminal penalties if you don't follow, right? So getting access to this stuff is pretty important. I don't think that California should necessarily be charging every contractor, money to read the code, but, Upcode's out there, so they actually have it up. Here's an example page of it, so quite good. All right. That's the main core stuff here. I just want to talk about one other group and a little bit about the free law stuff and really sort of who they're facing on. Then we're going to dig into the legal issues and then very quickly run through some resources we kind of covered in the mix here too. So that'll be super quick. First, Berkeley hippie guy right here, and Jake and his wife Tony. Here he is more recently, the non-legal book that he wrote. He basically founded NOLO. Right. And so NOLO was always focused on individuals, right? Not for lawyers necessarily. Sometimes they thought maybe they were in conflict with lawyers because they were giving information that lawyers might think you should get from us and pay us. But, again, different levels of things. If it's more complicated, obviously you would need a lawyer for different things. They were not against lawyers. They just also wanted to get the information out. they didn't, self-service divorce was one of the first things, but, patenting it, setting up corporations, a lot of the stuff you see right now done by LegalZoom or Rocket Lawyer, they actually also incorporate into their software and their products. This is Tom and Jake, from 10 plus years ago. One of the things that you see on the free law side is that most of the stuff that the free law people, whether it's us or, listener at Free.Law, Cornell, most of the people that actually come and look at this stuff aren't lawyers. They might need legal information, but they really need codes and regs to a large extent, or need explanations of the codes and regs. So it's, a lot of people go, okay, well, you're LII, Justia, you're going after, no, I'm not saying we aren't, going after Thompson, West, and Lexus. Yeah, of course we are. We would like to do it. We case summaries, right? We send those out daily. You should get those. We're very fast and quick, and it's free. But the great majority of the users are not lawyers, and they're people normally looking up a code section, or they're looking up a regulation. And what NOLO did is they provided easy ways to understand these things. And what sort of us, LIs, and the others did is we actually put up the raw materials, and then we've started working on adding explanations, right? So you have WEX on LII. Other site, again, there's different sites, different places. The blogosphere, right, has a lot of explanations of different things. But really, the core folks have always sort of been NOLO in terms of real good consumer information. So I always think of LII, NOLO, and Justia sort of, we look at both those guys. We sort of want to do sort of both, right? LI's made me a little bit more focused on academics, on professors and law students and undergrads. NOLO's very consumer oriented. We're trying to find our way in between it. But anyways, these are our buddies, and these are the people that we like to be like in terms of what we do on stuff. The last thing in this overview thing, the other one. These are the not fully free things, but the ones that are actually lowering the cost of research. The reason that you're not paying a lot of extra money for, like maybe you are still a bit, but for Thompson and Lexus, right? Who is it that came in or is coming in that's really making it, really changing the marketplace so there's cheap, at least at a basic level? And I've already mentioned them, and that's Fastcase, right? So Fastcase is the one. They've done all these deals with bar associations. They now have case makers a part of them. Both are now part of VLEX, which is a lot of technology, very international, right, in terms of stuff. But the Fastcase sort of US part, through us focus, is the ones that do all these deals with bar associations. When you're not paying as much for Lexus or West, you can thank Fastcase, right? Because they allow you to use them, at least for case polls, for different things. If you're not using the free stuff that they can reproduce and stuff like that, that's fine. They've got good stuff, right? And they keep it up to date. And now they're adding new AI stuff. They're spending a lot of time making it better and better and better. Citator stuff, all the little citation services, all the different things, right? And, here's Ed and Phil, the Fastcase guys, and then Luis and Angel from VLEX. And there's a good podcast at Law Next if you want to listen to them talk about what the future is. But these are the guys that will be driving sort of the lower cost for the attorneys in here. It could have been someone like Casetext, but Casetext is part of Thompson now, right? And this is the thing you always see. Thompson and Lexus tend to buy different things up. But these guys are part of, and I'm not saying VLEX might not sell to one. It's possible at some point. But right now they're the big dog here. And again, VLEX came in through Spain and then went through Europe. They're doing every place. They're doing Africa, they're doing South America, they're doing the whole world, right? And then Fastcase is the US brand, and they've got the relationships with all the bars. So this is, these are the guys I think that are really sort of driving down the price. So I'm not saying the free folks like us don't help drive down price a bit. We do. I mean, certainly for case polls, but so do the court sites, right? When you want to just get a court opinion, we all sort of work together to lower prices for lawyers. But I would say, probably a little bit the codes and regs will probably a little bit more towards non-lawyers in a certain way. These guys, this is aimed at attorneys and it's tied in with bar associations. So you should definitely check out. You have Fastcase access, you should use it. At least use it for your basic stuff. And these are the guys you want to in it, right? In terms of stuff. And then the other folks that are driving stuff down, then they have this Unicourt. So Unicourt's doing all the stuff with data with all the different courts. And again, like I mentioned, they were doing stuff with the free law folks. But they're also a great place just to find information if you're looking for different, different filings and different things like that. This is a great place to go. And they have, different sort of subscription plans if you need that. If you're a larger firm or a larger business, they got APIs. You can take the data and they normalize it all. It's fantastic. So they've got one business where they make a lot their core money on, and they have other stuff where they sort of provide it out to the public. And so they sort of have that combination of things. But they've done a lot of stuff, and they also work with, Docket Alarm, which is part of Fastcase and VLEX. They work with us on dockets, right? We all split costs in terms of making it cheaper. Again, Unicourt helped drive that process to make that happen. And so there's a lot of different things going on, but Unicourt has been the other one that, as you see different prices changing for you in terms of different services, they're actually helping drive down the price through competition and through some of the free access stuff that they give. And there's Judd, Josh, and Prashant at the, I think it's at Stanford Codex, is when they were there a few years ago, pre-COVID. And then finally, the bigger folks that you want to see take it over is the government itself. So a lot of the stuff, I know that I've been on different sort of groups with courts and things like that, working with working committees. You just want to help them do stuff. You want to give them code examples. I've done stuff with the Ninth Circuit and the Seventh Circuit out in Chicago and other California courts. And, it's not like they don't want to get things going, but it's hard. They got different, cost restrictions, different things like that. But the idea basically is sort of follow Carl's example where he did Edgar, got online for free, and then handed it to the government so they could run it, right? He was doing the same thing with the patents, and then they went ahead and they got the patents online back, in the late 90s. And that's what you'd like to see is government. And some states have done it, right? Illinois has all their cases on, right? Different states, there's a lot of states that have done it, Oklahoma, different places like that. They'll like to sort of get that going, but you really want to get the states work on, get the states coordinated on it, and give them free tech or free coding stuff on it. And eventually then they can run their own AI. Maybe they have their own AI projects and help them summarize their own stuff, which is, can work out quite well too. All right. That's the overdue. All right. A lot of history stuff, different things. We really need the government to do stuff, but everything's sort of, in a way, all these different individual actors, not overly coordinated. Maybe Kelly can help coordinate it. LAI can help coordinate it. But that's the issue. And then you got the big two coordinators. Well, big three now, right? You have Thomson Reuters, Reed Elsevier, Westlaw, Lexis, and now you have VLEX, right? And Fastcase. So those are your big three in there. And, VLEX, Fastcase, we want them to win, and they can help out on that on the legal research side, and that'll be good. All right. I'm just going through a few different legal issues here. Nothing major on it, but these are the ones that have popped up that have caused some issues with the free law stuff. So first, copyright. So back in the old days, back in the 90s, and even before I was taking final, I was still doing the programming stuff at SSRN. I went to this conference. Me and Martin went to it, and I think Stacy went to it. It was the Computers, Freedom, and Privacy Conference back in 95, I think. And this is Jamie Love. He was doing it, and he was sort of running stuff to try to get information out for free. And he was debating a former Democratic congressperson who was representing West's position in terms of having copyright on the page numbers and maybe some of the corrections of the cases. This is before the hyperlaw case, which I'll bring up in a few seconds. And it was a debate. And I remember watching that and I go, what the hell? What do you mean they're copyrighting the final version of law? That's crazy. So when I sort of got thinking about this stuff, is I talked to Jamie and said, what is this stuff? Because I was a programmer. I could program, do tech stuff. And that was sort of the initial thing that led me thinking of it. And this is again, long before FindLaw. And back when, back in the old days, after Tom Bruce released all the website stuff, but I was doing one economic site, and Stacey had a cyber law site, and Martin was writing his dissertation on contract objects or something like that. But anyways, this was the guy that sort of drove myself into it, but also drove a lot of people. I was running the CNI copyright list and a bunch of other things on it. And so one of the key things, what does copyright protect? So, original works of authorship, stuff that involves some creativity, not basic facts, basic system stuff. Some of that should be on patents. So the basic things, it's looking for stuff that's creative, not mechanical, is probably the way to think of it. And then there's, fair use as well. So, how do you use it? What's its core nature? Is it creative? Is it, sort of different ways of looking at it? How much do you use of it? What's the impact on the market in terms of what you're doing? And, is it a different market or is it hitting this market? There's lots of little different things. So normally if you're a nonprofit, not making money off it, you're doing something, it's basically mostly a government, primarily funded by the government and things like that. You can tend to do okay. There's also some exceptions, as you saw with the Georgia case, which we'll cover in a little bit, that, if it's a government work, whether it's not necessarily the federal government, some, especially involves the law, is done, funded by the legislature, paid for, work for hire type things, often that should be not protected by copyright, or and allow other people to grab it. So I'm not going to go through all the copyright stuff, but you can sort of read through it. But that's sort of the stuff that led to it. First major case involving copyright and free law was West versus Lexis. So Lexis and Westlaw, they used to compete. They were the ones that were law school. They had the terminals. Lexis was the first one to get this stuff online. They had the full cases online. They were focused on full text search. Really came by way of the Ohio State Bar and a professor or a lawyer that was doing some stuff with the University of Pittsburgh at the time. It's a longer story in terms of the full background of Lexis. But they had all the stuff up. And then West initially put up some of their summary stuff, some of the head note stuff, and then eventually they put all the cases up. West would note the page numbers in the West books in Lexis, in the Lexis output, so that you could actually see what the West page number was. And West sued them, saying we have copyright on that. And so there was a lawsuit. Yeah, Minnesota, of course, 8th Circuit, judge is pretty friendly to West, and West got the opinions they liked, and then they made a truce, right? Then they worked that out so that they didn't continue appealing it. But basically, the decision said, yeah, there's a copyright. The creativity is West's selection of the cases. So they select the cases, that's the creativity, and the page numbers sort of fall from their creativity. So it's really the selection that leads to the creativity. That the page numbers are an artifact of their creative bringing of the cases. And that was it. And then, but could have gone further to the Supreme Court, but they worked it out. So there's West, there's Lexis. So you go, well, what was the workout? How much did Lexis have to pay West? Now, granted, they litigated this up to these circuits. They spent some money on it. A lot of people were interested in it. They paid him $50,000 a year. Very little amount to get the full licensing in. But this was a secret. Nobody knew this was this much. So other people trying to do it didn't understand it, and West didn't, ask everybody for $50,000 a year to get, access to their copyrighted internal page numbers and things like that. This is actually discovered during the Hyperlaw case, is where this information came out later on. But that was it, and then you had sort of a duopoly, but with a small little payment going back and forth. Other companies started doing it. You could see, the Clinton administration folks thought that there should be a copyright in these page number stuff, but this is the 8th Circuit stuff, West would win, right? And then the offers weren't quite the same, right? They wouldn't quite do it, in terms of, they wasn't like $50,000 a year. So West really had this great decision. Granted, it was in Minnesota, basically for the 8th Circuit, but they were using that when anyone else tried to enter. And unless you had the internal page numbers, it was hard to compete in terms of the free law world. Then came Hyperlaw. So Hyperlaw was basically making CDs at the time. And they basically won a decision against West. And you could go read the whole, here's the decision. It's called Matthew Bender, but they got bought by Lexis, but it's really driven by Hyperlaw, because once Matthew Bender got bought by Lexis, folks, they didn't really want to continue. They were forced to continue on it. So even though the name's Matthew Bender, it's really Hyperlaw driving it. And that's Alan Sugarman, and that's Carl Hartman, the attorney on the case. Alan Sugarman was the guy who owned Hyperlaw, sort of ran it. And Carl, obviously, both are attorneys. Alan's also an attorney. The key thing here is they said, look, we're not trying to get the selection of the cases. We're grabbing cases, but when we get the cases, it might include all the cases of the book. It might not. We don't know. We also can have some cases maybe from outside of it. Is that we should be able to use those internal numbers. So once we get a case, at that point, the internal numbers become sort of just mechanical, because we need the case. And so from the case in the top number, which, is just a label in a way, not really creative to give just a number to it, then we need it. So it wasn't quite saying, I want a copy of West books, the collection, saying, I'm getting cases. I need to get the internal numbers for these cases. And beyond that, some of the other sort of corrections and stuff, that was not creative enough on that part as well. So they got to win in the Second Circuit. And the items I think drove this were basically twofold. One, I think a lot of the courts started putting up cases that weren't necessarily in the West reporters. So now people were grabbing stuff online that were outside of West. So no longer did West not just have the page numbers, everything else, but they're also and controlling the selection of cases. Now for the ones that they actually put, page numbers and stuff on, sure, they were doing that, but it was mechanical in nature, but people were grabbing in terms of once you have the case number, but it wasn't like people were trying to copy West's selection of cases. They were grabbing everything. It just had some also tied in with what West had put into their selected, volumes, in which case you want the page numbers. That was probably the bigger thing, was that stuff going online. Later on, it became also a big deal once Lexis started aggressively trying to get all the unpublished decisions and everything else, which, everybody still grabs today. Unpublished meaning published, but not for be used as a precedent for future litigation. And that then they became really aggressive. At this point, nobody thinks of the West volumes as like the official collection. It's just, they're there, but everybody has their own citations. Even the unpublished stuff, they might not have a, F2nd or F4th, where the hell the citation is, but they at least have a West citation or a Lexis citation or a docket number from the court. So those are the things that sort of changed around. But the big thing here is that Allen won the case, and he had to go through all the stuff. And you can go read the history. West was very, they really tried to raise his cost and make life hard for him. And, I worked at Thompson for a couple of years. I know other things, which I'm not allowed to say in terms of how they looked at it, but it certainly was the case. I think that everyone that does free law right now really owes Allen a thanks for actually taking this litigation on and fighting this part through, because without the hyperlaw stuff, we might have lost another decade. So he, maybe more, right? It really sort of drove the whole thing. So there's the whole hyperlaw case. You can go read all the history stuff on hyperlaw.com. All right, run through a few more here. Georgia versus Public Resource. This is recent, right? This is publicresource.org, the seal of approval, right? The great seal of approval. This is Carl again, right? Remember the Edgar stuff, and he does all the stuff. And what Carl did is that Carl got the Georgia code, and so there are a couple of things on this. First, the Georgia code was being published out. You had to get Georgia code, you had to go through Lexis to get it. And you could only buy it with the annotations. And the code itself was paid for by the legislature, and Lexis did work on it, but it doesn't work for hire. But it was all paid for and overseen by the legislative body at Georgia. And there wasn't a way you could buy a code without annotations. You go there's only sold one official code. It was with the annotations, and it said ignore these annotations at your peril, I think was some of the wording in it. In addition, someone like Fastcase that wanted to put the Georgia code up, Lexis wouldn't license it to them. So Lexis already had this license agreement with Georgia to put it up with the official code and even the annotations. But Fastcase, they had to rewrite all the headings. They could put up the laws, but the headings were seen as not part of the law. So they had to put their own headings on it. It's seen odd, right? But technically the headings are not part of the law. The session laws come in, they put it there. The headings are to make it easier to navigate, but it's actually not part of the law itself. Used to be that way on the California site too. They had no headings on stuff back in the old days. The old days being 10 years ago. So anyways, Carl saw this. I know, we talked a bit, but it was really sort of drove it. He said, look, this is ridiculous. They're not allowing it on. They don't even license it out. What is this? So we need to get this going. So he sat there and he wrote to them about it, and we'd done something similar in Oregon, where Oregon had threatened to litigate. And then by the way, their folks at a hearing, no problem. Go ahead and use it. We might keep copyright kind of, but we're going to let everyone use it. Just don't change the words. Right. That was the main thing they put out. But Georgia wasn't that way. Georgia, publicresource.org. And Carl was just like, look, this is the official law. There's only one copy of the official law with the annotation. I got to figure out what's what. I do know that you say I need to focus on the annotations because you say that in your preface of the document. So we put it up and it went through, and it went through a court case, right? And of course they were calling him a terrorist for putting basically the law of Georgia online, which, they're 9/11, a little bit strong. And there was a Supreme Court decision, Georgia versus Public Resource, and Public Resource won. And what was interesting here is that there wasn't a split. It wasn't a split where it's like the liberals versus the conservatives. It wasn't the split at all in the decision. The split was the younger folks all thought it should be available for everybody. Public Resource should be able to use it. And the older folks thought, no, this should remain with the state should have a copyright interest and not allow it. And that really shows a bit of a difference between the way lawyers are in general, because a lot of, especially judges, a lot of judges are very thankful for West, and they look at West and Lexis as being very helpful to them in their publishing process and everything else, and they're very connected to them. In fact, I have an old slide from the Star Tribune where I actually showed how West was taking people up to the Caribbean and stuff. Although I guess with just judges that might not be turned off yet today in terms of at least the justice level. I don't know on that, but there was lots of different things. They had lots of different relationships. I mean, West and Lexis loved by judges, right? Especially West, but Lexis too. But especially the older folks saw it. That was why, right? I mean, I was at an offsite once at Thompson. We had Steve Breyer came in and talked to us, told us how great we were at Thompson West. I thought, wow, it's interesting. But not, they weren't exactly free law at Thompson at the time. But at that point in time, but you sort of saw that break. But the younger guys all think, yeah, this should be online for free, and it doesn't make sense. So that was the break. It wasn't by who appointed you or anything else like that. And it was good. It turned out to be a good case. Now, that doesn't mean that this has solved things, because now they're obviously going to rework the contracts, try to make it so Lexis owns it and different things like that. And Lexis is still doing things like this. So the case, this case came out, what's the date of this case? 2019. There's a reply back at the beginning of 2021, but from a 2020 filing. And this is Lexis trying to do the same thing with the Tennessee code, but trying to file for a copyright with the Copyright Office. And they got a letter saying, no, you can't do it based on this decision, based on the Georgia decision. You can sort of read it there. And if you went, you don't get copyright on this now. But it didn't stop them from filing with the Copyright Office. They just keep going, right? And if they got a copyright, then they would bring that up if you put it up. So, I do think they'll change the relationships contractually to try to make it so Lexis owns it. And I no doubt about that. Not make it available in electronic format, so you have to scan it and type it. But anyways, this sort of still goes on, but this is a big decision to get stuff out there for free. All right, a few other ones, just code publishers. So lots of codes. Again, publicresource.org. There are codes, there are laws that get passed. Laws sort of say, hey, you can set up regulations. The regulations sort of take place. All right, that's fun. You got to put regulations there. And the regulations will often cite private standards. So you get a code, you get the private standards there, and it'll, I'm not going to read all this stuff to you, but basically it says you got to publish the regulation, but if it's a private standard, you can incorporate it by reference by mentioning it in the Federal Register or in the Code of Federal Regulations for the summary, sort of the summarization of the grouping of the Federal Register code, which is more like a session law feed. And so basically the private standards are out there, but it's mentioned by reference, and that means you have to go there to read it. Now, some of those guys would charge money for it, right? Some of the times it's referencing a code that's no longer even available to buy. And now, granted, if you're in Washington, D.C., go Library of Congress, and there might be some other places you could go to read those codes throughout the country, but it's not available to everybody. And so Carl looked at that, and he found ones that involve public safety and health and criminal penalties. And in the first one we did, I think it wasn't currently being published, being sold. It was an old version because they had updated their version. This is the old one that was actually incorporated by reference. And put that up, and started out there's been litigation going on. So, and they would say, no, you guys chose our standards because, and this is the argument the other side would make. You chose our standards because you're trying to take advantage of us. And then, of course, you go to the congressional testimony where they're saying, yeah, you should use our standards. We've already thought about this, and we worked on this a lot. And there's a whole sort of work with, Congress as well as some of the states saying, hey, where possible, use a standard that's out there. Because we private, public partnerships, but you still need to make the stuff available for people to read. That seems basic, especially when there's a criminal penalty involved and it involves the life, health, and safety of individuals. So anyways, this is a pretty big deal because a lot of times the industries want to get a hold of codes. They can also control what the codes say in certain ways. It can actually help industry in many ways, sometimes even more than safety of the workers. But the idea, listen, the basic idea, you talk to different folks, they need to find, what's sort of, tape or sort of, different sort of insulation or something can I put on some building or something like that? And they have to go pay, $1,000 a year to access the code stuff. All right, larger companies, still a big deal. Smaller contractors and stuff, it's a big deal. And this is not, I don't want to say it's just the federal government. This is state governments, city governments, any place that's referencing out these private codes, these private laws, these really should be available for people to read. Now, I will say this. I will say that when this project started a while ago, like this is a EFF article from over 10 years ago when things were beginning, a lot of these guys have now put stuff online. So I'm going to say right now, a lot of these regs, these private guys have now put online and made it available for free for people, which is really good. I mean, I want to say that that's a good thing. Not, it'd be nice if you could bring it in so you can incorporate with the overall law and you can make it, searchable thing and sort of add in all the different sort of filters and stuff to help people research and get their answer better, rather than having to go from this database to this database by way of a link, but at least it's online. However, I don't think that would have happened without this litigation. And it was the fact that some of the judges said, hey, this doesn't seem reasonable that someone could be put in jail for a number of years because they harmed someone because you were going to charge them $1,000 to read something, especially after you went to Congress and told them to use yours. Doesn't seem reasonable at all. So this is still going on. By the way, there's still other litigation going on for different standards. Some standards don't involve health and safety. Some standards involve other stuff as well. Not non-health. There's a lot of standards out there from standards bodies. And it's also international, right? This is also having different countries. Every country has the same issue with private standards, private laws impacting people, which is not always readable by everyday people. So this, again, sort of an additional part of the free law movement, but this is on the public resource side with Carl and sort of his litigation effort. All right, this is a quick little throwaway one. This is, Zotero wanted to use Blue Book stuff in their little plugin that they have. They have a version for law. And the Blue Book folks said, nah, they can't sort of do it. Again, talked with Carl stuff. Carl talked to some other lawyers. They came up with the Indigo book. They found a version of it that was out of copyright. Not a lot of changes. They worked it out. They're not calling the Blue Book, they're calling Indigo book. It's a color of blue. And now it's in this Jurism thing. So now you can use it for Blue Book citations within a plugin. But again, the idea that a lot of times Blue Book citations are required by courts in certain ways. You can buy the book, you can get the online stuff, but you should just make it available for people. I mean, I'm not saying, it's not the same as having access necessarily to a regulation involving fire hazard, but what are you doing here? I mean, if you law reviews and stuff, I know they need to make money and things like that. Maybe have a sponsor of it or something. Get one of the big firms to sponsor it, but they're trying to make money off every single thing. I don't know. But this actually exists right now, and you can use it. The Indigo book and Jurism integration. So very good. And then the last one I want to cover here is this White versus Thompson. So this is actually interesting. So this is a case where Ed White, or maybe two Ed Whites and another guy, they lawyers basically sued Thomson Reuters and Reed Elsevier, Westlaw and Lexis for having their briefs online, saying, hey, look, I wrote the briefs, I wrote the copyright on it, right? And now you put it on. And they sued. And they lost. So West and Lexis get to keep it, sort of use it within their collections, sort of a fair use type of stuff. All right. And basically was the argument that came back. And that's interesting because that means they can basically grab all the briefs and have that on their systems. Now, there might be different ways depending how they use it, right? Maybe it's okay. They can have it as a collection so you can sort of see what's going on in the court case. Could they take those briefs and also create AI out of it? I don't know. That might be a separate issue. But one of the other things I just want to note, they also collect all the attachments. Here's another case with Warner Brothers involving the Superman comic book. And this is a judgment order. This is an order from the judge. And he's starting to scroll down there. But anyways, here's the important part. A full reproduction of the original Superman comic contained in Action Comics Volume 1 is attached as an addendum to this order. The guy put the whole comic book as part of the order. Now, certainly the comic book, has copyright. It's not yet as old as Mickey Mouse, is the initial Mickey Mouse stuff. Here's the comic book. It's an attachment. Each attachment had 2 pages, but not just the top page, each attachment. Well, there you go. I mean, interesting on that part. So I'm going to keep going. So I realize some people, the hours here, but I've got more stuff I want to cover. I'm just going to go over. So I'll do that periodically. But this is a good break if you got the core copyright stuff. The other stuff, it's sort of a little bit more secondary in terms of importance. Or you can watch it later on YouTube or on our videos platform. But let me just sort of keep going here. Privacy issues. All right. This is the second thing that comes up a lot with cases, especially in the US. So here's a list of different files that were downloaded. These were different attachments and documents that were downloaded from Pacer. So there was a brief period of time where Pacer allowed you to actually download stuff for free if you went to certain places, like certain libraries and things like that. And this guy, Aaron Schwartz, who died, actually committed suicide, did different things going on with a different thing he's working on, but very big in the free law world. Had downloaded all these documents and taken them and put them online and then shared them over to publicresource.org and Carl and stuff like that. And so Carl got these documents, and listen, the FBI's talking to Aaron, the FBI's talking to Carl. And Carl took all these documents that they got, and he went through and said, you know what? I'm not going to just put these documents online because there's a lot of stuff that's there. But he went through and he said, where can I find, certain privacy issues, right? Like social security numbers or driver's license numbers, and went through all the documents he has and took them by the courts and gave them grades. Like some got A's, some got, F's, right? In terms of it. And then sent a report back to the different chief justices of each of the district courts. And you can see here, the A's, like, Northern California District, California got an A, Florida District got an A. Some of them would then have cases from, some got F's, some of the ones in red, Western Pennsylvania, things like that. But really just went through, and again, the scores were scores. But the big thing here was there were tons and tons of social security numbers at different privacy things. And here's just a couple examples. Like there was one where, there was a filing that had the social security numbers and medical problems of 353 patients of a doctor, right? There's another one where a guy had not been paid by a school, so he put in the names of all the kids that he was treating with their home addresses and their psychological issues, right? There's another one here. In Alabama, they constantly were putting in the social security numbers and different things, birth dates of police officers and state employees for some reason. Anyway, there's a bunch of examples. These are just some of the highlights of it, where they had tons and tons in just these particular types of filings. But this stuff, should be redacted. Now, what the courts eventually said, well, that's up. The lawyers are in charge of doing that. We're not taking responsibility for it. Although, Carl gave them some scripts that they can run to easily find it. It's not, 3-digit, 2-digit, 4-digit, not too hard to run a script on it. And similar for driver's licenses and other personally identifiable information. That type of stuff that happened, that would be harder to happen in the European Union. They're a little bit more tough on that stuff, right, than the U.S. U.S. has not done a very good job in terms of privacy of people. Really hasn't on it. So there's a lot of different things that go on. And again, you put these stuff online, it can really hurt people. Especially big companies, that's one thing, but individuals, it's the first thing that shows up. Especially things like dockets, where sometimes the stuff's very one-sided and not necessarily always true of different things. It's not just court documents. It's also things like social security numbers of military personnel getting increases in rank. They used to publish the names of the military folks in the congressional record at certain levels, and it was captain above or major above. And they post them with their social security number. It took them a long time to remove this stuff. In fact, it didn't really get removed until this article in Stars and Stripes showed up. Even though the opportunity to remove it earlier without this, but it just took a while. For us, we have a way that you will remove it from search engines. So, I'm not saying, I can think of some particular cases where we might fully remove a document, right? As well as a minor or something. There's a couple of things. But court cases we don't remove, but we will remove it from Google and the other search engines. And that really tends to be the main thing, is so they don't show up in search. That part. And it's not just us. There's a bunch of us free law folks that work together to remove things. And then with Google, you can also go in and get things removed for your name. So if something shows up for your name, you can get it. I'm not saying the document will be removed out of Google, but it'll be removed out for any name searches involving you. You just have to show what the information is. Normally, they're looking for personal identifiable information. But Google has a removal tool, and you can certainly contact them there if you have something that you want removed, or you have a client that wants something removed. With us, just ask us. We'll put robots on it. And we'll take it out. Unless you're like a huge company or something like that. If you're, some large companies, we're not necessarily going to do it because Walmart wants all their stuff removed. That might not be happening. But anyways, those separate items, or a Supreme Court case. We'll remove the Supreme Court case. Public access. Again, this is basic stuff. We sort of covered this within the mix. This is of Cato saying, it's talking about Carl. And again, Cato was pretty conservative, very pro free info. And as has been a lot of the right. I don't want to say this is like a left stuff, but a lot of the people on the right side of the aisle also want a lot of information up, maybe for different reasons, but they certainly want it up. So this is a statement on something Latin, but it means ignorance of the law is no excuse. The cartoon I found online here, ignorance of the law is no excuse. I didn't know that either, right? This sort of type of thing. Yeah. But if you can't read the laws, you got a problem. So the basic stuff that we see, text is available online. You can try to address that. That's a bigger thing. You can get it. You can access to view it, but it costs money. Again, this goes back to not there at all. Next thing is you got to pay money for it. And for those types of things, sort of brought up the code examples out there. And then sometimes the text is wrong. And this is the thing that sort of bothers me the most to a certain extent of the public access part. And I'll give you just an example. Here's the Mississippi Code. It says Mississippi Code annotated, but they only really have annotations on it. Where the previous history is on this. But this says, any mirrors, this is the current code, not later. And I've used this in my AI talks as well, in terms of how autocomplete can be wrong sometimes, in terms of using AI. But any marriage between a person of the same gender is prohibited and null and void. That's what it currently says. So if you're a Mississippi resident, you go and you look up the code, you might not be happy because the code is basically not the current state of the law, because it doesn't take care into context federalism and everything else that goes with that, right? In terms of the Supreme Court opinion. But you got to understand, codes are legislative intent documents. That's it. They're not necessarily the law. And when you put up an unannotated code, you put up a legislative intent document, and yet people think it's the law. And so individuals don't understand that nuance at all. So the failure to put up the annotations or just correct their code to the current state of law, which they're not going to do because it's really about what was passed by the legislator, and the legislature in Mississippi, I don't think is going to pass same-sex marriage, even if it's legalized anyways, at least right now. There should be something done here, because a lot of people then take this and then they might be breaking law or doing something illegal or not recognizing something, even though there's a Supreme Court opinion that's overriding it. And this, again, if you want the annotated stuff, you get that from Lexis. Georgia one, again, it says this is the one where you actually got the annotations up as well. So they did not distinguish between the annotations and the actual code, because what's written as one work for hire by the legislature. The key thing there was written by the legislature. Even though the annotations technically weren't law, the fact that they were clarified by the legislature actually made them a public document for all purposes in terms of how they interpret the law. So that was a key thing here in the public resource case as well. They didn't come and say, all right, you can put up the code, but you can't put up the annotations. No. Both were okay. So relatively important. They could have split it that way had they wanted to. All right. Well, I'm going to keep going. I'm going to do free law and AI. This won't be dead. So first, remember this guy who used AI and then cited weird cases that were wrong? Don't do, and listen, I'll point up here because at some point someone will put a link to the other videos that I've done on AI and ChatGPT. But don't just use ChatGPT for this, okay? Just don't, or at least double, triple check your work, or write prompts that force it to try to get better autocompletes. AI is not like some knowing thing. It's an autocomplete system. And I'm not going to go into the details of AI. We've covered that in other videos, but you don't want to be this guy. All right. So first thing is, there's a bunch of big players here. It's really, what's really new about AI is the amount of power it has in terms of doing these autocompletes. And there's OpenAI, there's Google, Anthropic, there's Meta, Facebook, having their Llama stuff. And then a bunch of projects using some of these other models, like Stanford has a project. There's the Open Llama project that you can get on GitHub right now. Some of this you go on your computer, some you need other systems. You can get different training data. Some people, technically you can use models to train models if you want to. Want you to do it, but it is happening. Lots of stuff going on. So again, very beginning stages of it, you don't really know who's going to win. My guess is be one of the big four that we mentioned here. It'll probably be OpenAI with Microsoft to a large extent. Google, Anthropic really tied in with Amazon right now, or Facebook with their Llama. But and we're doing tech stuff with law. So this should get getting cheaper and cheaper and faster, right? We're not talking yet about making movies using AI. We're just talking about trying to process text and classify and summarize documents and find relationships and patterns. So things should be getting better and better on those things. To me, AI is going to end up being just like spell check, grammar check. you're going to use it. So I wouldn't even, again, just use it. That part's, I think that's just a given at this point. Everyone's saying, yeah, you can use it, but you got to check your work. All right, well, check your work, right? I mean, same with anything. You like key cited separatization. Again, you use this all the time if you're a practicing attorney. You'll end up using AI the same way. In fact, you'll be using it anyways, even if you don't know you're using it, because Thompson and Lexis are going to use it to summarize their case and find the relationships and actually tie it into their search and everything else to help you find the relevant information, as is VLEX and the other folks using AI for it. I mean, classify it, you can find the different relationships, you can find relationships between cases. Lots of ways to do it. And it could process huge amounts of data pretty quickly. So a lot of things you can do if you have good data that you could do good things with for a while, and that will happen. The question is it only going to be the big two, big three companies now with VLEX, or will other people come together and make something really good that's useful and free? All right. Legal side, case text, of course, now part of Thompson, right? There's Thompson. They were part of that. Lexis has stuff. VLEX. For the law side, there's other ones. There's guys doing contracts and other things. Like, I don't want to say these are the only ones that are out there, but these are probably the main ones right now with Thompson, Reed Elsevier, and VLEX. You should try them out. You should see if it helps you. It should be helping them reduce cost. I do know that they're now using it to charge you more. I'm not saying there's not charged cost involved with it, but it's primarily, a lot of the AI is primarily to help Thompson not to need as many editors in India, right? To write their summaries. And which has been happening for years. I mean, Thompson's pretty good at AI stuff. I don't want to say their engineers are quite good. But again, you got to check your work. Don't be this guy or this guy. I mean, this is no excuse here. It happened many times after. At least he caught it before and told the other side. But you got to check it. You can't just use AI. You got to check the cases and things. Come on. I mean, basic. I mean, that's basic stuff on that part. All right. Data availability and accuracy. All right. Here's the ChatGPT stuff. They were using the Common Crawl. And Carl's on their board as well on that part. Justia was one of the top sites on it, but really Justia's collection of government documents are one of the top sites. The number one site, by the way, was Google Patents. The main thing I would point out about this, though, is that there's lots and lots and lots of government documents out there, right? Court Lister has a lot of documents. The law guys, right? They have tons of documents as well. There's, Google has lots of government things too. Their court stuff. But there's just tons of stuff. So you got the court documents, you have all the other federal government documents, you might have other documents you have from state governments that you can use. You go to the federal government, they have a whole data set search. You can find all types of different government data sets with Google, right? Give you a huge data dumps of documents. I think you could do a pretty good job if using government documents to train a lot of these models. In fact, I would say that using the web in general is a little bit iffy because a lot of the stuff on the web is really, really crappy, right? Even stuff written by law firms sometimes isn't too good. So the government stuff tends to be better. I mean, granted, don't do Trump's tweets if you don't want things in all caps and misspellings and stuff like that. But a lot of other government stuff, that part of the official record is quite good. And that'll be a great place to train it on AI, right? A lot of this is really, really good, regardless of how people feel about the deep state. That said, not all government documents and different things are equal, right? You got the accuracy issues. A lot of people say, oh yeah, we're grabbing all the pacer data. We're going to run autocomplete off that. So we'll grab great briefs. Well, this is a brief, right? Written by a pro se guy, pro se plaintiff. And it's told gibberish, right? I took out some of the personal information that he shouldn't have filed with it. But there's a lot of stuff. There's a lot of really crappy briefs. If you go ahead and you look online, right? I mean, these guys wrote some briefs too. They got their own issues, right? You got to look through it. There are things where, again, you autocomplete stuff off and you're using government data, but the data's wrong. Getting back to the Mississippi Code, right? That we're talking about. This is not true. Yet if you used AI for it, this one said it's not legal in Mississippi. I showed this in the previous AI talk, and then this one says it did become legal because of the Supreme Court case. AI doesn't always get it. AI is just auto-completing stuff. If your data is bad, it'll auto-complete bad stuff. If your data is old, it's going to auto-complete off old data, right? our web crawl's up to 2021. Well, a lot of those documents were from before, 2010. Might be different bankruptcy laws, might be different all types of stuff, right? Especially in law. You really got to be careful. So I much prefer, if I was really doing legal stuff, to use a legal data set, whether it's VLEX or Thomson or Lexis. I'd be really hesitant using ChatGPT because a lot of the data it has is going to be older data, right? It's just the way it is. And a lot of it's going to be non-law, and a lot of it's going to be opinion pieces or Reddit threads, right? Reddit, you can end up writing all types of crazy stuff. So ways you can make stuff better if you are using ChatGPT, you don't have access to other ones, put in detailed prompts, asking it to explain how it does things, right? Is same-sex marriage legal in Mississippi? And please explain the steps you took to get the answer. Anything you do to actually make it do extra work tends to take it to better sources and better autocompletes. I'm not going to go into all the details right here, but I say prompt engineering, but making your prompts more detailed so it doesn't just autocomplete something really quick, right? It's the same thing. If you ask for details, it has to try to answer what you asked in terms of what the autocomplete would do. To answer a question like that, it's just a little bit more detailed. And of course, you get all types of stuff, right? The venting sexual harassment, all types of stuff can happen with ChatGPT, right? Or any AI to be that matter, right? Copyright and authorship. All right. Well, you got the PACER documents, right? You got SEC, patents, and trademarks, right? The reason I bring this up is you got two separate collections of documents. One is stuff that's actually produced by the federal government itself or different states. The laws, the regulations, Congressional Research Service reports, or whatever, GAO reports, right? That's produced by the federal government. The other stuff is stuff that's produced by individuals in private filings for the federal government. So that stuff, okay, well, we saw the fair use case that, where Wes and Lexis one, they could put up the briefs and things like that. But, could they put up that Superman comic and resell it? Could they take the Superman comic and then use that for autocomplete? What happens if I attached all of Dave Chappelle's comic routines in some litigation I'm doing because I think, for whatever reason, I'm suing him or something. If I add every single routine he did, that gets picked up by Thomson and they put it into their AI. Now they use that for making an auto joke completer, right? Just because it's filed with a government filing, does that make it, what is that allowed to be used for? It's maybe be allowed to use for if I'm going to look at the case to see what was argued and what was attached to the case. That's different than saying all these documents can necessarily be used for AI. And I don't think that's been resolved at all yet. But there have been instances like there's a case where I think the entire Harry Potter book was attached. If that's attached, you could probably use prompts in a way to actually get the book back. Does that mean it's no longer copyrighted? Right? And could they just use it however they want? So the use cases here becomes a little bit more important on the fair use side. And I don't think right now people have thought that part through. Certainly they didn't think it through when they started using AI for all the OpenAI and everything else, which is why New York Times is suing and other people are saying, hey, crawled our content for your OpenAI stuff. And you can easily get back the full story. This isn't right? In terms of how you use your prompts. So there's a lot of different stuff going on here. And while there's government documents, there's also these filings attached to government documents. Again, you've got the just your case filings, you've got contracts filed with the SEC, patents, trademarks. There's a lot of work product, either from that's owned by your clients or owned by the law firm, right? Depending on how the ownership goes on that. That can then be used by your competitors using AI to write a brief against you, right? So in that part, even if they're just using it to research you, there's all types of different things that can go on there. So there's a lot of different stuff here that needs to be resolved. And it has not been resolved, not just for OpenAI and Google and Anthropic and Meta, but also for the legal folks using their backends but on different content sets. Again, this is the same thing. This is the fair use case that Thomson won in there. It's the Superman thing, which again, we brought up. But again, this could have been Dave Chappelle's jokes, right? Could be anything. Privacy stuff. Again, lots of private stuff's there in this information that's being indexed. And you can use AI to sometimes pull this information out. So unless you've added privacy filters on top of your data, some of that data can come back. Sometimes they'll just make it up, as we saw with the previous one, but also there's some real privacy issues here on that. Okay, that's the basic core of the talk. A little over. Resource stuff, I'll just really quick run through this, just like a couple seconds. Court cases, we got Supreme Court Center, we got daily opinions at Justia. That stuff's pretty good on different things, lots of different opinions you get daily. Harvard Case Law Project. good for getting stuff. Again, you can actually get all this data if you want to do your own project in a few weeks. Case Text has, not forget about just the AI stuff, but they also have good cases and codes and different things on their site. FindLaw still has some cases and codes. Leave it there. Court Listener, part of the free law stuff, has really good stuff too. And Fastcase. Most of you guys are lawyers. You should have access to Fastcase or whatever else you can sort of do using the Fastcase BWEX partnership. And they'll have a lot more AI tools and things like that. They're really good. Docket stuff, we have our docket stuff. There's Court Listener and Unicourt. Again, depending what you're looking for, I think the recap stuff, Court Listener might have more stuff on lots of different topics. We have certain selected cases. Unicourt has like lots and lots of stuff, almost everything. I mean, that's sort of a bigger play on that part. And then for basic, legal information and codes, you got LAI, you got us, you got FindLaw, Case Text again, Fastcase, basic stuff like that on that part. And then just, free law folks in general, these are sort of the main ones that I see. LII, the biggest one that starts everything. The Free Law Project, sort of, in the mix with LII. Public Resource Art with Carl, sort of also handling the litigation stuff like that. NOLO on the consumer side, still the best. And Fastcase in terms of the stuff that they're doing with for lawyers, especially with bar associations, and of course, there's Justia. Of course, I'm missing us. We have lots and lots of stuff on that. So with that, I will stop and stop sharing my screen. And I know I went over. I hope it was okay, but if not, apologize. And if you left, you can watch this end part. We'll bring in the segments. Okay, we'll leave it there. I'll hand it back to you.
Thanks, Tim. Since we're almost out of time today, we are going to go ahead and wrap things up. We want to thank you for joining us today for another Justia webinar. And in the spirit of free law, we wanted to mention, just as we did at the top of the presentation, you have a great free law resource that's available to you as a Justia Connect member in those Justia daily opinion summaries. By signing up, you get those free next day case summaries and updates sent to your inbox. You can select your jurisdictions and practice areas that you want to receive those updates on. To sign up, it's completely free, and you can do so by going to newsletters.justia.com. Thank you all again for joining, and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.